Everyone, thank you for joining us. I'm Rena Nine, and we're learning more about an interview between the president and special counsel Robert Mueller's team, exactly what it might look like. The president surprised his lawyers earlier this week by saying that he would gladly cooperate with the Russia investigation. Here's what he had to say to reporters yesterday.
I'm looking forward to it, actually.
Do you have a date set?
Here's a start, just like I said. There's been no collusion whatsoever.
To reach a higher standard, you would do it under oath.
Oh, I would do it under oath, yeah. Absolutely.
CBS News Justice reporter Paula Reid is in Washington. Paula, you've got new information about the missing FBI text messages. What can you tell us?
That's right, Rena. We have been reporting over the past several days about the fact that thousands of phones used by the FBI, Samsung 5 phones over the course of a year, weren't actually storing text messages. But today, the Office of Inspector General at the Department of Justice has informed Congress that they have been able to use what they describe as forensic tools to recover these text messages. Now, these text messages are significant for many reasons. The first of all, because between June of 2016 and about May of 2017, that is the period during which these phones failed to preserve this data. That, of course, spans the Clinton email investigation and also large, very key, critical periods of the Russia inquiry as well. But in addition to that, if the FBI isn't storing this kind of data, they also don't have a lot of evidence of internal corruption, evidence critical to sexual harassment cases or sensitive cases the FBI is investigating. So there are a lot of questions about how it was possible that the FBI wasn't storing this data, but it appears at this point the internal watchdog for the Justice Department is telling Congress they have been able to recover these texts.
Okay, that's good to know that they are looking into that and have found that, Paula. I want to switch gears for a second and ask you about what the president said, that he would speak under oath in the Russian investigation. First off, is that really possible?
Well, you don't speak under oath when you just are talking with investigators as a witness, when you sit down for an interview, as many top White House officials have in this investigation. If you are asked to testify before the grand jury, then you do go under oath. So the president might be confused about some of the legal nuance there, but he says that he is willing to sit down with special counsel investigators for an interview and answer some questions. But at this point, there is no discussion of him testifying before grand jury and actually having to go, as he said, under oath.
So what would be the president's involvement in the investigation as of right now?
Well, if he does sit down for this interview, he doesn't have to do that. It's still an open question of whether or not he will sit down for an interview, answer written questions, or some combination of both. It's likely that these investigators are going to have a lot of questions for him, specifically really about this question of obstruction of justice. They're going to want to talk to him about the firing of James Comey and also other criticisms and conversations that he's had with other top justice officials. Criticism he's had for his own attorney general, some conversations that he had with James Comey's successor, Andrew McCabe. They're going to want to talk to him about things that he's said to them publicly and privately, and to get to the heart of the question, which is, were you trying to use your position to tamp down the Russia investigation?
Do you get a sense, Paula, of what the defense might be that the president's team would offer in an obstruction of justice case or charges?
Absolutely. So let's take the firing of James Comey. They're going to say, look, even James Comey admitted the president has the authority to fire him. The director of the FBI serves at the pleasure of the president. He has the authority to fire him for really any reason. And here they'll argue they had a good reason because of the unprecedented way that he handled very publicly the Secretary Clinton email investigation. They could also say, look, this guy isn't from inside the Beltway. He didn't know you're not supposed to ask for a loyalty pledge from the FBI director over dinner. Furthermore, if it comes to conversations he had with Andrew McCabe, they could argue that, look, he just has bad manners. He didn't know you're not supposed to ask who you voted for in an election. But, Rena, the problem is the more times you need to explain away one of these instances, it becomes a pattern of behavior, not just a one-off. And a pattern of behavior is really central to obstruction of justice.
Interesting point that you make there. I'm curious, Paul, if there would be some sort of a record available to the public, a transcript, an on-camera recording that could be witnessed or reviewed.
The president made a big deal about the fact that Secretary Clinton's interview with the FBI was not recorded and that there was no transcript and that she wasn't under oath. The fact is, though, that is how most FBI interviews are handled. There is no recording. There can be if you want one. There is no transcript. There is a report, a traditional report that FBI agents who are there, lawyers, that they prepare, a sort of summary of what they learned. But it's unlikely that anything from this interview would be made public. That's not usually the way this works. But this is, of course, a case of enormous national significance. So it is always possible it may be leaked or a court may choose to reveal it for another reason. If, however, he goes before a grand jury, that testimony can be made public if a judge allows it.
I'm curious about, instances of this happening in the past with past presidents. You think of Bill Clinton during the Lewinsky scandal. What do you make of that?
So everyone remembers that famous video of President Clinton sort of talking about that case on camera. Well, that was his grand jury testimony. They worked out a deal where he didn't have to come down to court to testify before the grand jury. He could do it on video. Eventually, that was, of course, released. That's why we see it so frequently. But that's the next phase. That's grand jury testimony. If the president and his lawyers want, they could certainly request a camera for this interview that the president may or may not sit down for, but you really have to wonder why they'd ever want to do that. If you read previous depositions that the president has given in his previous life as a businessman, he's the consummate executive. He's not who you see on Twitter. He's not who you see on the campaign trail. He knows the drill. He knows that there are potential legal consequences to lying in these settings. And there's a possibility that if you introduce a camera into this kind of case, we're not arguing about zoning laws, we're not arguing about, a dispute with a contractor. This is very personal for the president. There's a lot of ego involved. And I think his lawyers may be concerned that if you introduce a camera when you don't have to, you may get perhaps not that consummate executive that we've seen in previous depositions.
A lot to consider. Paula Reid, thank you for weighing in on this.